Welcome to another edition of The Oath and the Office, the only constitutional law podcast with inappropriate humor you need. I'm John Fugelsang. People of Earth, let me welcome the man with a PhD in politics from Princeton, a law degree from Stanford, and he uses them to enrich the lives of students in the poli-sci department at Brown, the author of The Oath and the Office, Professor Corey Brettschneider, but around here we call him the Mac. Corey, it's good to see you. Congratulations on the ratings for this thing, huh? This thing is getting popular in spite of me.
People are coming, I think, largely because of you for our dynamic, and we hit number 2 on Apple Podcast Government last week, that amazing discussion with Sheldon Whitehouse. We have an amazing episode today with our return guest, Leah Litman from Strict Scrutiny, also the author of the amazing book Lawless. And what a moment, too, because we're going to be talking not just about the birthright citizenship case, but also about the oral argument this week about the question of whether or not the president can fire at will for political reasons the head of the independent agency, the Federal Trade Commission. That sounds dry. We're going to unpack it, but we're also going to talk about why it's nothing less than the future of our democracy that's at stake.
Yeah, Corey, for listeners who aren't up on this sexy stuff, I haven't thought about Humphreys since AP government. What is it? Why have conservatives wanted to get rid of it for so long?
This is a case that asked the question in the 1930s, as you said, can Congress protect its own laws? Can it create agencies that are so important that they have to be insulated from political firing? And the court said very clearly in Humphrey's Executor, yes, that we are going to allow Congress to assert its legislative power and protect itself by ensuring that there are agencies like the Federal Trade Commission in particular that are insulated from the whims of a president, from doing the president's bidding rather than pursuing economic well-being, for instance, of the country. But the fact that this precedent of the Supreme Court has existed for so long, and this law that it upholds has existed for so long, it looked like from this oral argument that the court was willing to say, we don't care, that if it violates the Constitution, that's the end of it. It's very similar to what they did in Roe versus Wade in the sense that they said, we don't care how long there's been a right to an abortion, how long the courts recognize this again and again. We, the Supreme Court, now have the votes to wipe it away, and we're going to do so because, on our view, it's unconstitutional. I should say what a bogus argument, and I know we'll talk to Leah Litman about this, it is that there is a constitutional prohibition on Congress protecting the independence of these agencies. There's really just one sentence in the Constitution that they rely on, the conservatives, and that's the idea that the executive power is vested in a president. And that idea that one sentence gives them the authority to just overturn this case, I think is just wrong-headed, because what executive power meant in the founding, and common sense says it means, is the power to execute laws. It has nothing to do with undermining the power of Congress.
Okay, then let me bring it up to the Fed, because we know that Trump has been wanting to fire the Fed chair because the Fed chair refuses to falsely juice interest rates to try to hide the damage that's being done to this economy. And so that's where I think everybody's mind was on yesterday, because if Humphrey's executor fails, then one of the big questions is whether comb over Caligula here can now fire the Fed chair for not juicing interest rates before the next election. Now, I'm not an optimist, Corey, but I kind of think the Fed might survive, because even conservatives know that letting Donald Trump fire the Fed chair would be like giving a toddler a chainsaw and saying, only use this when you're upset, right? I mean, how much danger is the Fed actually in? The fact that Donald Trump is less popular among Republicans than ever in our government is helping me think maybe this won't happen, but how much danger is the Fed really in after the arguments this week?
Well, I think that, as much as you would hope pragmatism would prevail, if it prevailed, it would prevail in this case. And Justice Jackson was raising many of these worries about handing over power to a wannabe monarch. And they were really going nowhere, I think, when it came to the conservative majority. And I think the way the conservative majority sees it is that this isn't a question of pragmatism, it's a question of law. And they have a case on their side. They cite a case called Myers, which is about the ability of a president to fire at will a postmaster general, an earlier case to Humphreys. And they say, well, that's the right way to see it. Humphreys is not. And they just argue this solely in terms of law. So when it comes to the question of the collapse of the economy, of okaying mergers because your family members are involved with them, that's not really what they were talking about in this oral argument. And my worry is that they really don't care about it. It isn't a new concern. The unitary executive theory dates back to at least the Meese Justice Department, and Edwin Meese talked about this case, Humphrey's executor, and the need to overturn it. He thought that Richard Nixon, in the post-Nixon period, that we overreacted. We restrained the presidency too much. And the key was really to restore the dignity of the president by increasing his or her power. Now, when we were thinking about Ronald Reagan, he was no Donald Trump. He wasn't corrupt in the way that Trump is. He certainly had problems, but not on the order of magnitude of destroying democracy. So you could see how if they were thinking about Reagan, or thinking about great presidents, no problem. But when you think about the reality that we're facing now, it's a different universe. And so the lack of attention of pragmatic considerations, and also the bogus argument that somehow this is based in the text of the Constitution. It doesn't say anywhere that the president has the right to fire at will, or that Congress can't protect independent agencies. So and yet in Roe versus Wade, they made such a big deal of the text. So I think that unfortunately, they don't care about pragmatism. They really just care about their own commitment to overturning this case, Humphrey's executor.
Oh my God! I mean, so let me ask one more question about this before the break, because, Corey, Pete Hegseth. It turns out that he only did that double tap to murder those unarmed people with no evidence on the boat because he was due to speak at the CPAC prayer breakfast, and he wanted to get the murders out of the way. We're now having senators, military experts, international law scholars. They're all describing Pete Hegseth's double tap strike as essentially murder, as legally a war crime. And I would argue that they've all been murder. All 80-plus souls that we have snuffed out with no evidence, with no due process. We don't allow cops to murder people they think might be bringing drugs somewhere. And when this is happening while the president is pardoning the president of Honduras who smuggled 400 tons of coke in here, I mean, it's going to take the rest of our lives to figure out how deep this hole goes. But how, as they're calling it a war crime, how does this intersect with the court's growing push to try to shield Donald Trump's executive actions from any kind of accountability? It seems like we're moving towards something there, and I don't think Pete Hegseth realizes the immunity ruling doesn't apply to henchmen.
That's right. And, I had a viewer email about this, too, asking, how can members of this administration be prosecuted if the attorney general, simply doesn't want to do so? But now we're starting to see the reality, which is that not only do they not have immunity that the president likely does have in cases like this, but Pete Hegseth is becoming unpopular. You're starting to see Fox News turn on him. Former colleague of his, Judge Napolitano, is I think how you say his name, was talking about the fact that, yes, this was a war crime, because if you know anything about the law and you see this, really what we're talking about in this second attack is a disabled ship people being murdered. And it's a textbook war crime on the military's own understanding to, imagine capturing somebody, having them lay face down and shooting them. Well, disabling a ship, and as the ship is essentially sinking, to then commit murder is not just a war crime, but literally a textbook war crime. So we did cover this last week, but I think the update is that now even MAGA, now Fox News, everyone who sees this is embarrassed and turning on Hegseth and not going to pretend that this is okay. And so you might see him abandon. I hope that he will be, and maybe even a prosecution. It is that bad. And Hegseth was worried enough that he started blaming this admiral for doing it. So this is not a story that's going away. It's horrific. We'll keep covering it, keep talking about it. And no, he does not have immunity in the way the president might. It doesn't carry over to him. And in fact, he might have committed a war crime that can and should be prosecuted.
If I had slept with this guy, with Corey Lewandowski, I would want to murder a dog to have something more disgusting than that on my resume. Go on, please.
The other reason to cut her off might well be that as these contempt hearings proceed, that she's implicated. And, in the same way that Hegseth's illegal action might result in him being thrown under the bus, so might the Homeland Security. The head of Homeland Security, Kristi Noem, might also be thrown under the bus. And, all of this goes to the point that if you act illegally, It's not guaranteed that you'll face justice, but there's a good chance, especially when the political winds start to turn against you. And so that's the hopeful part of what we're seeing right now, that the law has this chance of prevailing in the case of the disobeying Boasberg's orders, even in the case of Hegseth and his illegal action. The more that we, in our show and other shows, put the light onto these illegal actions, the greater the chance that they will eventually, I'm not saying it will happen immediately, be prosecuted.
Well, Judge Boasberg, Professor, says he intends to, let me quote him, to find out what happened that day. Is this essentially the judiciary investigating whether the executive branch committed a crime? How unusual? How unusual is that?
Look, in a functioning democracy, that's exactly what's supposed to happen. In a functioning democracy, the Department of Justice has a lot of trust, and there's
Well, that's why it's so foreign to me. Then I guess.
But yet now, and we heard this from Dahlia Lithwick in the episode with her, that kind of presumption of trust is gone. Not only that, but the presumption that they haven't committed crimes is gone. And this judge well thinks that a crime was committed. He knows his order was disobeyed. Somebody made the decision to do that. It wasn't an accident. And that's a crime. And he wants to see it prosecuted. This, by the way, is a Republican nominee, not a Democrat. So it's not purely partisan. It really is somebody who's trying to stand up for the rule of law. And I really have to just applaud Judge Boasberg, and the rest of us should see it as what it is, a defense of the rule of law.
And I want to point out the hero here is Erez Ruveni, the whistleblower who alleged that the DOJ leadership said the administration intended to ignore court orders. Corey, we got to hit a break, but really quick, if that testimony holds up, what does that mean legally? Is this conspiracy to violate a federal court order if a cabinet secretary knowingly allowed the deportation flights to proceed after being told to stop, which seems to be the case? I mean, is it just a crime? Is it a constitutional crisis? Is it both?
Well, contempt of court, criminal contempt is a real thing. If you defy a judge outwardly, and conspiracy might involve, multiple people, yes, that could be prosecuted for contempt. And let's see, there's a good chance that's going to happen. But let's start by talking about this oral argument. We've introduced the case. The question of the unitary executive and hiring and firing in some ways seems abstract to people, I think, but it's, as you of course, will help us to explain, so important to the structure of the federal government. So tell us, both what's at stake in your view and how it went in this oral argument.
Yeah, there's so much we could talk about with respect to this oral argument. I guess what's at stake is whether there are going to remain pockets of independence and expertise within the administrative state, which of course is like the most powerful and effective part of the federal government today. Like that's how most federal regulation gets done, through agencies like the Federal Trade Commission or the CFPB, the Consumer Financial Protection Bureau, or the EPA, the Environmental Protection Agency, you name it. And so the question here is whether the president has to have the power to fire everybody who heads these agencies, because the president has to have the power to fire anyone who exercises significant executive power. And if you want to understand the implications of that theory, look no further than who is leading HHS or who is leading, the Department of Defense /war, right? Like when you can install these political nut jobs, that just absolutely vitiates the ability of the federal government to serve the people's interests. And he wants to do this with, again, the entire administrative state, including agencies that, the National Transportation Surface Board, right? And other agencies that just do super basic stuff. They want to absolutely blow that up as well.
So
what's
essentially,
your feeling about? Oh, sorry, John.
No, I'm just essentially every agency head would be a political appointee serving at the mood swing of a given president.
Every appointee, every agency head would be doing pull-ups at the airport in order to prove their loyalty to dear leader. The justices basically spent the entire time asking the lawyer for the federal government, John Sauer, to tell them how smart and correct they were. At one point, Brett Kavanaugh is of course, the Federal Reserve Board, that's different. And John Sauer is well, of course it's different. You said so. And it's just that sort of unthinking, reflexive reciting the talking points of the right-wing legal movement that just made my eyes and ears and brain want to explode.
But what is the, I mean, one kind of follow-up on this is, I have no doubt that they're going to do what they want to do. And that, as you've argued often in the book and on this podcast, that there is no theory really underneath a lot of it. But if we try to give them some of the benefit of the doubt, what is the argument once they've said that the executive power includes this vast hiring and firing ability, once we've gotten rid of Humphrey's executor and the idea that legislation can be created by Congress, it's within its power, that's protected from political firing? I mean, what is to at least conceptually keep them from using this unitary executive theory and going so far? And I'll add to that, not just in the Federal Reserve, but getting rid of the Pendleton Act, which, protects civil servants from political firing. I mean, why not give it all to this wannabe dictator?
I mean, why not, right? That was basically the subtext of this oral argument. I'll talk about giving them the benefit of the doubt, but, part of what, again, was so frustrating about this oral argument is at one point, Justice Barrett asked the lawyer, who was asking for the court to embrace this theory, do we even really have to identify the part of the Constitution that is the basis for this theory? Like, they're so convinced that the theory is correct, but they don't know what in the Constitution actually requires this theory. Like, she just admitted it. So, like, conceptually, what are they getting at? I mean, if you read what they write, if you listen to what they say, they are really convinced that, one, the framers of the Constitution made this decision that all of the executive power is vested in the president, and therefore the president has to have control over everyone exercising significant executive power. Like, as if the framers were completely unconcerned about a king.
Yeah.
Right.
Oh, they wanted a king. They missed it. They missed having a king.
The lack of textual basis, the lack of historical basis. And then they add to this notion that their theory, the unitary executive theory, is really awesome because it's great for democracy, because the president is democratic. And it's like, have you heard of Congress? Right? Because Congress writes these laws that creates these agencies and limits the president's power to remove them. They're democratically elected and democratically accountable as well. So I don't know why you think the president has to win in these cases. So, those are the foundations they have given for this theory. And it's just very frustrating that they seem utterly immovable based on any contrary evidence, because it's not like I'm saying things they haven't heard before. I mean, Justice Jackson is saying, well, what about Congress? They're Democratic. Justice Kagan says, okay, right. You used to think, the people who came up with this theory used to think that the framers maintain that the president has to have all of this power. But in the last 40 years, there's been all of this historical scholarship debunking it. Justice Jackson says, okay, there's the vesting clause, which puts the executive power in the president. Congress has the necessary and proper clause that allows them to make all laws necessary and proper to give, the powers of other departments, right? And to allow other departments to carry into those functions. And so, notwithstanding all of the contrary evidence, they just continue marching down this road. And I don't know why.
Do you think that this court will just sort of refuse to see that major questions doctrine as a limit on presidential power and instead see it only as a limit on agency power?
Yes, but I don't think they are going to rule for the administration in the tariffs case, because they have other ways of advancing this anti-regulatory agenda, and they hate taxes, right? And for them, tariffs are taxes. And so they look at the Constitution and they say, okay, it has this libertarian bent, right, that is skeptical of taxes, and therefore, right, the president doesn't have the sole authority, right, to do things that amount to taxes, even though the president has the authority to do a bunch of other completely horrible, terrible, no good, very bad things. And so I think, they are going to rule against the administration on some things. I think they will do so when it serves the ideological project of the right-wing legal movement, and on issues where the Republican Party is split. And frankly, ruling against the administration on tariffs will be good for the Republican Party, right?
Yes,
Nobody
yes.
These tariffs.
Yes.
And so, I am
it's a maybe.
right? But
Yeah.
like I just don't think the reason is like some principled account of the major questions doctrine.